The answer is, it depends. If the prenuptial agreement was signed on or before June 28, 2013, when the law was amended, and it wasn't voluntarily revised after that date, the person that wants to uphold the prenuptial agreement must prove that the person that wants to void it entered into the agreement voluntarily, and the person that wants to void it had the opportunity to have the agreement reviewed by a lawyer of his or her choice, and that the person that wants to uphold it disclosed all of his or her assets, liabilities, and income. If the person that wants to uphold the agreement can prove all of these things, the only way the court will refuse to enforce the prenuptial agreement is if the challenging party can prove that it's now unconscionable to enforce it. To prove that it's unconscionable, the party that wants to void the prenuptial agreement must show that if it's enforced, he or she will be rendered without a means of reasonable support, or he or she will become a public charge, or his or her standard of living is far below what was enjoyed during the marriage. The law changed substantially when there was an amendment signed on June 28, 2013. And if you have one of those, the burden of proof is now on the person who wants to void the agreement to show by clear and convincing evidence that he or she signed it involuntarily, or the agreement was unconscionable when it was executed, and that at that time the party was not provided with full disclosure and did not voluntarily waive in writing any right to disclosure, and that that party didn't have and reasonably could not have had knowledge of the property and financial obligations of the other party, and that that party did not consult with a lawyer or voluntarily waive the right to do so.